Today, I'm going to begin by reading a letter from the governor. Dear councilors, I'm pleased to nominate Whitney J. Brown to the position of Associate Justice of the Westborough District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker. I'll first introduce the councilors, and then we'll hear from the nominees' witnesses. So we have Councillor Terry Kennedy with us today, Councillor Bob Juvenile, joining us remotely, Councillor Chris Iannella, Councillor Eileen Duff, Councillor Mary Hurley, and Councillor Joe Ferreira. And so with that, would you like to ask your first witness to step up and join, or will we be going remote?
I have two witnesses who are remote, so I would defer to whoever's doing that.
Okay, let's begin with Judge Haley. Judge
Good morning.
Haley, are you ready to join us? Hello, good morning.
I am. Can you hear me?
We can hear you. It's a little quiet.
Okay, I'll speak up then. Thank you for providing me this opportunity to speak on behalf of Whitney's nomination for the district court bench. I've known Whitney for in excess, I think, of 15 years, both personally and professionally. I know her to be hardworking.
How's the audio sound in the room?
She's knowledgeable in the law, and I believe she'll be a fine candidate for the district court. I can't think of any better training ground for a judge than to be a clerk magistrate before they are nominated to the bench. In fact, that's my own background, and I can tell you from experience that you have a level of comfort that most people wouldn't have just from having run a courtroom and sat facing the audience as opposed to having them at your back as you advocate for clients. The jurisdiction of the district court is so broad that I think it would be rare for any litigator to have experienced all of it. Just before today's meeting, I was thumbing through Connors and Perlin's treatise on the civil jurisdiction of the court. That book has 26 chapters, runs to 600 pages, and it covers the myriad of different hearings that are conducted in the district court, from dog appeals to firearm appeals, unemployment appeals, marriage without delay. The list goes on and on and on. Only a long tenured judge, as Judge Hurley, I think, could probably tell you, or a long tenured clerk would have experienced all of those many different types of hearing. The criminal jurisdiction is similarly broad and nuanced. It's, we deal with everything. I guess, the district court, which I used to be a part of, deals with everything from minor misdemeanor motor vehicle charges to bind over cases of capital offenses. Everything seems to start here in the district court. Whitney has spent much of the last 15 years in the courtroom, in my experience. So she's observed not just myself, but a number of different judges. She's been able to observe different temperaments, different pacing in the courtroom. And so she can take a little bit from each judge as to what she thinks she might want to have for her own persona. I know I did that myself. The Yankees great Yogi Berra once said, "You can observe a lot just by watching." And I think that's true. I mean, she's been in the courtroom, she's seen it all. She's seen a bunch of different people do the work. I should add a caveat here. I'm not a Yankees fan, but Mrs. Brown is from New Jersey originally, and whether or not she is a Yankees fan may be a legitimate area of inquiry for the council. To those of us who have worked in the district court or have worked in the district court, the highest praise you can give another member of the team is to say they get it. Whitney gets it. She understands that everybody that comes before the court is in distress of one sort or another. She understands that all of those people are entitled to be treated fairly and with respect. And she understands that the exchanges between a judge and counsel in the courtroom don't occur on a level playing field. and that a judge has to take care not to undercut or embarrass counsel as they make their arguments before the court. On more than one occasion, I've come out of the courtroom and Whitney or one of the other clerks has said to me, the lawyers want to know why you're in a bad mood. And I'd go, I'm not in a bad mood. And it's such a slight thing to the person on the bench, but being aware of it, you can take care not to put a counsel in a difficult spot with their clients. And she understands too how hard it is to practice law and the demands of private counsel's schedules, so that sometimes you can be there in time, sometimes you can't. It's the nature of the beast. I think it was Benjamin Disraeli who said, the secret to success is being ready when your opportunity arrives. In my view, Whitney's ready. If you approve her nomination, I'm sure she'll find great success on the bench and serve with great distinction. I would encourage you to act favorably on her nomination for a number of reasons. One of them is that my guess is that once this COVID matter is put to rest, the courts are going to be tremendously busy. With Whitney's vast experience, she'll be ready to hit the ground running. Thank you for the opportunity to be heard.
Thank you very much, Judge Haley. And I'll open it to any counselors who may have questions for you.
Mr.
Any
Chair,
of the
I
remote
don't have a
counselors?
question. It's Mary Hurley. I just want to say hi to Judge Haley. We served together. He was a model for appropriate demeanor and temperament, and it was a pleasure to hear from you again.
Nice to hear from you, Mary. I think you might be mistaking me for someone else.
I don't think so.
Thank you, Mary.
Any other counselors on the remote call? Well, thank you, Judge Haley, for being here. You dropped implications of the nominee's Yankee fandom, and yet you had many marvelous things to say. So I think that speaks well to this nominee. Thank you.
An exception to my Yankee-hating rule for Mrs. Brown. Thank
And that's
you
a
all.
powerful, it's a powerful statement. Thank you for being here this morning. Okay, and is Clerk Magistrate Maldonado remote as well?
I am.
Good morning.
Good morning. Good morning, council members.
Good morning.
Thank you for the opportunity to address you today regarding the judicial appointment of Clerk Magistrate Whitney Brown. I apologize in advance if I'm difficult to understand. I had some surgery last week, so my ability to speak clearly is not up to par. I have worked along shoulder to shoulder with Mrs. Brown for almost the past 16 years, and I believe that puts me in an excellent position to evaluate her ability and character. Clerk Magistrate Brown was appointed to the Gardner District Court in 2005, after serving as the first Assistant Clerk Magistrate of the Middlesex Superior Court. As often the case, there were some concerns regarding the appointment of an outsider. It didn't take long for those concerns to diminish. Ms. Brown made a seamless transition into her new role. Her professional demeanor embodied her commitment to this position as well as to the community. She quickly gained the respect of the local bar and the district attorney's office. Ms. Brown enjoys interacting with the public and has the ability to bring a situation from 100 to 0 in a matter of seconds with her calm demeanor, genuine concern, knowledge, and ability to make people feel that they are being heard. It is a rare occasion that she will pass by the clerk's office, by the counter in the clerk's office without inquiring if someone needs assistance. Ms. Brown has gained the respect of the staff in the clerk's office by having an open door policy. Employees feel comfortable approaching her with whatever concerns or questions that they may have, and know that the outcome may, even though the outcome may not be in their favor, that they were able to be heard and understood. She has the ability to motivate others to achieve their highest potential in the workplace and will stand behind each one of them. Ms. Brown is a woman of solid integrity and genuine compassion. She is very conscientious and capable in the performance of her duties. She constantly displays a demeanor and temperament that is calm, pleasant, courteous, and respectful. She is well-versed and knowledgeable about the law, the legal process, and the district court practices and procedures. She's a disciplined, reasonable, and patient individual with a temperament suited for judicial office. To share the impact that she has had on the community in our area, she and I were at lunch one day, and a defendant approached the table to thank her. He stated that having been before her in a clerk's hearing made him feel as though he had been heard, and she had given him the opportunity to redeem himself when he was at a particularly low point in his life. I myself have the privilege of not only being able to call her my boss, but also my friend. Whitney is a woman of great character. She is empathetic, respectful, and loyal. She is trustworthy, thoughtful, and has a great sense of humor. Having become her friend has also allowed me to become close with her family members, including her wife, Betsy, children, Addison, Cole, and Spencer, along with her mom, Carol. They have raised, Whitney and Betsy have instilled the true meaning of love within their family. They have raised exceptionally bright, outgoing, and caring young adults that all share a genuine respect for one another. I feel confident that my 36 years experience working for the trial court adds to my ability to assess this candidate. While I am happy to endorse her candidacy, I will miss my friend, the daily laughs we shared, the comfort in knowing that I always had someone to talk to, work-related or personal, and the fact that there was always someone there who had my back. I would be remiss if I didn't state that this would be an application that would lead you to no regrets, and ask that you act favorably. Thank you.
Thank you very much for that. And we'll open it up to any counselors who have questions for you. Any counselors remote have questions?
No questions.
Thank you. Thank you for your comment.
Well, thank you very much for being here this morning. Wish you a fast recovery, and we appreciate you sharing your perspective on the nominee.
Thank you.
Thank you. And finally, we have a witness who is with us today, Attorney Max Berwick. Good morning, Attorney Berwick.
Good morning, council members. Thank you for your time. I've had the pleasure of knowing and working with Whitney Brown for approximately 10 years during her time as clerk magistrate in the Gardner-Winchendon District Courts, and during which time I've been a practicing attorney in those courts. I can tell the council members that I believe Whitney would be an excellent addition to the ranks of district court judges in Massachusetts. I found her to be courteous, respectful, and just in her rulings and her role as the clerk magistrate. The Gardner-Winchendon District Courts, like many in the Commonwealth, are courts that handle a number of small, close-knit communities. And as such, we see a lot of the same individuals in and out of those courts on a daily basis, whether as repeat defendants, parties to civil cases or to restraining orders, harassment orders. And regardless of the individual's history of transgressions in front of the court or what brings them to court on any given day, I've seen Clerk Magistrate Brown treat them all with dignity and respect, and I've very much admired that. Similarly, when individuals have been in those courts suffering from physical or mental health disabilities, I've seen Whitney extend those individuals every possible accommodation of the court to make sure they have a favorable experience and they're treated equally. And I, again, very much admire that. What I've also really grown to admire her willingness to give individuals second chances. I think that's probably the most important role of a district court judge. Whether it be in default removal hearings, in pre-charge clerk magistrate hearings, in bail hearings, I think I've always known her to listen with an open ear and attentive ear, and to really give individuals a second chance whenever deserved, regardless of their history in front of the court. I think, again, she's someone, although the clerk magistrate's role always involves a number of day-to-day tasks, whether it be keeping an accurate record, organizing the next case to be called, whether or not it's an issue she's required to rule on, whenever attorneys in her court are making arguments, I've known her to really have her head up, be focused, be attentive, and really digest everything that's being said in court. And that's always struck me as a real desire on her part to be constantly learning. And I think that's going to greatly aid her as a district court. Finally, I think one thing that I really wanted to mention to the council is that, the majority of my interactions with Whitney over the years have been inside the courtroom in a professional sense. But despite that, over the past year during the COVID pandemic, there's been a couple occasions when she reached out just to express to me her appreciation for my work for the court and just to check in and make sure that I'm doing all right. And although it was, it's minor gestures, it didn't take much time, that they did really mean a lot to me. And I think that her actions probably mean similarly as much to everyone she's worked with, all the people that appear in front of her in the court as a clerk magistrate, and certainly everyone that would appear in front of her in the future as a district court judge. I really couldn't endorse her more. I think she would be an excellent addition to the job, and I would encourage the council to act favorably upon her application.
Thank you, Attorney Berwick. Are there any questions from the council for the witness? Councilor Devaney, and then
Rich, and this is Richard. And this is Alyssa.
Is someone else talking?
let's hear from Councilor Devaney, Councilor
Thank you.
Juvenile, and then I'm not sure who is talking remotely, but we'll.
Thank you for coming. I always like to see someone eye to eye. Tell me, how long have you worked with Whitney Brown?
Approximately 10 years.
Really? Wow. So what would you say is her greatest attribute that she's going to bring to the bench?
I really think it's a combination of her compassion and how she treats individuals in the court. Regardless of someone's demeanor inside the courtroom. I mean, she's certainly no pushover if people are being disrespectful,
Yeah.
but she treats everyone with courtesy and fairly. She doesn't let personal things step in the way of her role of being a fair and impartial clerk magistrate. And I think as a district court judge, that's going to be it.
So do you work with her on a day-to-day basis, or?
I would say over the past 10 years, I've been in Gardner District Court probably an average of 2 to 3 times a week.
Wow.
There are a few, in-session clerk magistrates, but I'd say about a third of those days have been with Whitney.
So you really know her temperament, that, when she's under stress or all of that. So how would you rate that?
Well, I would say that really what I've learned most about when she is or isn't under stress comes from personal conversations. I would never think that I would know that from observing her in the courtroom. She has an even temperament and she treats people fairly. And really what I've learned about what, rubs her the wrong way would be from, personal conversations. You would never take that from her in court experience.
Yeah. Well, that's great. Well, thank you for coming. I appreciate you coming in.
Thank you for having me.
Councilor Juvenile?
Thank you. How long you been practicing?
Since 2007.
And you mentioned that you see the same people a lot of times coming through the courts. So I've always wondered about that. And I always wonder why, if you went through that system once, why you would ever want to go through it again. Why do you think they do?
That's a very good question. And I think my honest answer is I don't think they want to do that. I think a lot of people have difficulties getting out of their own way, whether it be financial difficulties, mental health disabilities. And I think what I was mentioning is also just not individuals necessarily appearing repeatedly as criminal defendants, but as party of civil orders. And I think once you get yourself in some criminal trouble, sometimes people end up in circles of individuals where problems create themselves. But I do think one thing I admire about the Gardner Court is that a lot of individuals, regardless of that cycle, do manage to get themselves out of that cycle and move forward with, successful lives. And I think a lot of that is to credit to the court. Court system treats civilians.
Yeah, I think I've come to the conclusion that people can't help it. So we just keep recycling them through.
I would agree.
What are they doing in the Gardner Court and is Winchington still open officially?
It is. They're combined into one building, but they operate somewhat separately in the clerk's office, but they're all.
What happened to the old building up in Winchington?
I'm not positive. I believe maybe it was a lease issue. I think it was somewhat of a smaller courthouse. And I think it may have made sense to combine it to one.
Well, thank you for your testimony. It means a lot to me. Thank you.
And I'm not sure which of the remote counselors had questions, but please. Or are there none?
We're all set.
I have
Okay.
none. Thank you, Counselor.
Okay.
I don't have any either. Thank
I'm on
you.
a governor's council meeting right now,
Thank you,
but
thank
they
you.
can't,
Well, Attorney Berwick, thank you for being here today. I think it's great to hear from a practicing an attorney and a bar advocate who's worked with the nominee, and it speaks perhaps to her fitness for a district court position.
Thank you.
So thanks for coming out to Boston today. Pleasure.
If you don't.
I'll first ask if there's anyone here to speak in opposition of this nominee. And there being none, perhaps before we hear your statement, you'd like to introduce your family who's here with you today?
All right, thank you, Councillor. I'm so happy and so pleased to have my family with me here this morning. I'd like to first introduce my wife, Betsy. And I also have with me one of my twins, my son, Timothy Cole, and also my daughter, Addison. Unfortunately, my daughter, Spencer, who is Cole's twin, is unable to travel because of the COVID restrictions from her university. Addison is joining me and has given up a day of law school. She's a second-year law student. And Tim will be starting college in the fall because of the pandemic. He deferred his enrollment. So I want to acknowledge and thank them because I wouldn't be sitting here today without their love and support and have been with me every step of the way through this process. And I'm very grateful for that. And I'm grateful for the opportunity to have them with me today, even though like is still ongoing.
We're glad you were able to have them here with you today. So I understand you have a statement prepared, and
I
please
do,
feel free.
Councillor. Thank you. Well, I want to start by saying that I am absolutely thrilled to have the opportunity to be before you this morning. And I'd like to take this opportunity also, in addition to my beautiful family, to thank some other people who have been with me along this journey or aided me in getting here today. And I think when they say it takes a village to raise a child, it takes a village to get to the position I'm here today. So many people who have been supportive me along this journey. I want to thank Valerie McCarthy, who, with all the logistics leading up to today and my remote witnesses, has been instrumental. I want to thank Lauren Green Petrino and Bob Ross for their professionalism and their support throughout this process and their guidance. I want to thank Governor Baker and Lieutenant Governor Polito for having the confidence to nominate me for this position. And I want to assure them and you, if I do get the privilege of representing, serving the people of this Commonwealth in this position, that I will do everything in my power to assure that this council and this administration can look back on my appointment with pride. In addition, I'd like to thank my family, my extended family in New Jersey who couldn't be with me today, who I know, like my daughter Spencer, I'm sure are watching, my mother, my brother Tim and his wife Susan, my niece and nephew Katie and Harry, my brother Pat. Again, but for COVID, they'd be here today, but I'm unable to have that. I guess what I'd like to do is tell you a little bit about myself as you contemplate my nomination today. I was born and grew up in New Jersey. I am the oldest of 3 children and the only daughter of Whitney and Carol Brown. As I discussed with Councillor Juvenile this morning, yes, I was named after my father. My parents married soon after high school and started a family. My father was a teamster and drove a truck for a living. My mother, when she went back to work after my brothers and I were in school, she was a bookkeeper. Neither of my parents had the opportunity to attend college, but I can tell you that the importance of education was ever present in our home, and they encouraged us to educate ourselves. After high school, I went on to college. I attended college on a 4-year athletic scholarship for basketball. And after college, I went right to law school. In order to pay my law school tuition, my mother took on a second job as a clerk in a pharmacy, and my father painted houses on the weekends. It was always my father's wish that I were to become a lawyer. And it's something he talked about with me since as far back as I could remember. And I lost my father 17 years ago on this very day. So when Councillor DePalo suggested the date and my hearing fell on his anniversary, I knew that it was more than just a coincidence. After law school, I began practicing law in Malden. That firm focused on real estate, banking, and estate work. And while I was there, I had the opportunity to do some pro bono work. I appeared in the district court, the probate court, and the superior court. I was appointed as a GAL out of the probate court. I sat on medical malpractice tribunals in the superior court. In 1993, I left that position to accept appointment as the first assistant clerk at the Middlesex Superior Court. And I served in that position for 13 years. I left there in 2005 when I was nominated as the clerk magistrate of the Gardner District Court. And then in 2011, the Chief Justice of the District Court appointed me as the acting clerk of the Winchton District Court. And I've held these positions for the past 16 years. So I come before you today with 31 years of legal experience and 28 years of experience in the trial court. And during these years, I have worked with many judges, many attorneys, many pro se litigants, and I've spent literally thousands of hours in a courtroom. And during those hours, I've conducted small claims trials, show cause hearings, probation detention hearings, bail hearings, civil case management conferences, and motor vehicle appeals. In addition, it's always been my practice to work at the front counter in the clerk's office, to pick up the telephone and to answer calls, to make myself available not only to my staff, but to the attorneys, to the litigants, to the families, and to the public, which I think is extremely important because those are served. I cannot imagine a better way to have prepared myself for this moment. I would be humbled and delighted to serve the Commonwealth in this new and exciting matter as an Associate Justice of the District Court, and I would hope that you find me qualified to do that. So I thank you for your time and your consideration on my nomination.
Thank you very much. I'm going to open it to questions from councilors, and we're going to start first with Councillor Duff.
Hello, I appreciate it. It's nice to see you, Attorney Brown. I don't have a lot of questions. I was very excited about this nomination. You have great references, many of whom have reached out to me, and some unexpected as well. But I did want to go over with you a couple of things we had talked about. One of the groups of folks that I'm concerned about, and I know that you've had some experience as a clerk magistrate, are when people come into the district court and they have any kind of different ability or disability, be that a physical or a cognitive. I get concerned about people that we may not always recognize something that could have a negative impact on them if it's not considered. I hope I'm making sense saying this. Can you share any ideas or experience or thoughts you've had working perhaps with people who might be on the spectrum, autism, Asperger's, or any of the multitudes of issues like that?
Thank you, Councillor. I have worked with young people a lot, and you may have seen in my application in terms of with schools and in doing show cause hearings. Many times the population that you see in that are young people. But overall, yes, I've had some experience dealing with people who have had physical or mental challenges. And I think it's very important for a court to realize that as early in the process as possible, because I think it's our job, especially a district court judge's job, to make sure that this process is understandable to every individual who comes before the court. And we have to amend and alter the way we handle that proceeding to make sure that happens. Whether that to be slow down the proceeding, to appoint counsel, to assist that individual step the matter back so they can have things explained to them. It's important that everybody get treated with respect and everybody understand what's happening while they're in the courtroom.
Yeah.
In addition, I think there's even physical challenges. In Gardner, we have one attorney who's in a wheelchair. And I remember just seeing him struggling to get in and out of the courtroom door, to get into the door for probation. And Ours is an older courtroom, so it really wasn't handicap accessible. And I went to the Capitol Department of the trial court and had them change out some of the door hinges and things that would make the doors open easier for him, and asked if we could install some sort of automatic doors and change the tension on the doors so that he could get in and out with less struggle. And although it wasn't a big deal for us, I'm sure it was a big deal to him. It's another complicating factor with, that he was trying to get through the day. So I think there's so many different people who come before the court, and we need to be cognizant of what their needs are to make their experience as fair as the next person who comes into court.
Thank you. Thank you for your thoughts and for your action on that. Like I've said before, when someone with any type of cognitive disability, particularly commits a crime, it doesn't absolve them of the crime. It may mean that they don't quite understand things the same way we do, but we do need to make sure that we are making sure they're safe. But for what you added about helping that attorney who was in a chair, I deeply appreciate that. We're talking about building diversity in the courts and on the bench, and making courts accessible for lawyers with all different abilities is really important. And I don't know that we've been as cognizant and aware as we could be. So thank you for that. And I have no further questions. Thank you very much, Chairman DePalo.
Thank you, Councillor Duff. Councillor Juvenile, would you like to go next?
I would, thank you. The issue of COVID, which has impacted our courts, and now they're talking about starting to open it up a bit. What is the latest you've heard as far as district court trials happening again?
Well, the Supreme Judicial Court just issued another standing order, and the district court order, I think it's 1319, came out effective March 1st. And March 5th, we were supposed to start resuming jury trials, phase 2 of the overall plan. I know Chief Justice Carey recently sent an update saying that we have leased 4 spaces in 4 different counties, and 2 additional counties to be added soon. We're going to try to get jury trials up and running. The plan is for 1 jury trial in each of those locations, and then once that gets underway, to add maybe 2 or 3. We're starting with criminal cases where people have been in custody, which I think is an appropriate place to start. And then as we move forward, I think we're going to try and pick up a speed as quickly but as safely as we can. So right now we're at phase 2, and the resumption of, if any, have actually taken place as of yet. But the trial court is working very hard, cognizant of the burden that it's placed on, the public not being able to move forward with trials. Because although we have thousands of cases, to those individuals, many of them, it's their only case and their whole life revolves around that. So to have it put on pause for such a long time and to carry that burden and that stress for a long time, I think has taken its toll. I think the administration, the SJC, Justice Carey, and the district court are doing their best to get those trials up and running.
One thing I don't see in the orders or the discussion is the issue of wearing masks during a trial. Your position on that?
Well, I think, we have to defer to the state and the CDC in terms of safety. And we have to be very cognizant of how people feel. We're summoning them in, we're asking them to come in and participate in these trials. And I think we have to provide as safe an environment as possible. I think with social distancing, ideally, it would be nice if the masks could be removed. So for clarity in terms of being able to understand what people are saying, and just so that it gives some normalcy to the proceeding. But at the same time, I think safety has to be paramount. So I think that would be, a call for someone more, in terms of a health professional than necessarily the court, I think.
The thing that concerns me is on the criminal side of the court. You as a judge or lawyer or prosecutor or the jury, how do you determine whether a witness credible or not when they wear a face mask?
I think that's a valid point.
We have over thousands of years as humans developed a technique of looking at people's faces, determine reactions, and to decide whether or not we feel a threat or we think somebody is not credible with us. We've learned that through our lives. I'm sure you as a clerk, and whether you were sitting in a courtroom as a clerk or whether you were doing clerk's hearings, get a sense of whether somebody is telling you the truth or not by the way they look and act with their facial features. So to me, I'm all for safety, but not at the expense of taking away somebody's ability to have a fair trial. I think having a fair trial, one of the things about having a fair trial is to be able to see the witnesses testifying. And equally as important to me, probably the prosecutor, was a judge, able to look at jurors, see their reaction to certain things that go on in the courtroom, or to see whether or not they're paying attention, concerned about certain issues. So we read a lot in faces in a courtroom. Jury's always looking at a defendant, or reactions, or lawyers. Get jurors to see their reactions. To go down a certain area and questioning. I guess my question is, you're sitting as a judge. I have a case in front of you and I, set to go to trial. They expecting to people wearing masks when they're on the stand, or jurors. What's going to be your reaction?
Well, I think your points are well taken and extremely valid, and I share those concerns.
What's going to be your ruling?
Well, I think that you're right, that needs to be addressed. And I think that the burden would be on the trial court to create a space that is safe where people can remove their masks. Because I think we're balancing that with also you don't want jurors who are afraid or apprehensive, who are worried about their health and safety, not really paying attention to the proceeding, because that's not fair to the defendant either. If they just want the trial to be over, they want to bring it to conclusion because they're concerned that they're in this space. So I think we need to balance that. And so I think I would do my best to balance it and make it fair for the jurors so they can be relaxed and participate fully in the trial. And you're right, also allow the defense attorneys, the prosecution, the defendant, the judge also to see the reaction of the individual. I think that's extremely important.
So they seem to have in these courtrooms a lot of plexiglass, witness stand, have it around the jurors, certainly protects them from airborne viruses. I know some judges have said to me that they add up to a decision based on prosecutor and the lawyer. If you two guys agree or two women agree to forward with the masks, fine. If you don't, then give you a new date. Because at some point down the road, hopefully we will not be wearing masks. not in the way we do now. Me, unless somebody is incarcerated and kind of issues. Why not continue matters? I mean, yeah, we're going to have a big backlog, but we'll get to it. We've had big backlogs in the court system before, and we've worked through them. I just don't think enough is being given to that issue. For a trial, that is extremely important. Prosecutors and I have discussed that, said, yeah, very important to them too in the courtroom. But you as the fact finder, extremely important too. How do jurors get a reaction from some witness with a mask on? Sometimes you look at a witness testifying and you look over at the jurors and you can say they're not believing the guy or the woman. That's all taken out of the equation right now.
Oh, I agree, and I have many times been able to tell by someone's demeanor and their expression, whether it be in a show cause hearing or other, whether or not I find them credible or I believe what they're telling me. We haven't had to deal with that as much in those circumstances because everything now is being done by Zoom, and I haven't turned the camera on, so I still have the ability. But you're absolutely right. If we're going to bring people back and do in-person trials, that is a very important court is going to have to grapple with.
Well, the issue with Zoom also, it's fine in my view for certain things. But as far as having trial with witnesses on Zoom, or I've been at hearings where I can see the witness looking down at his police report as he's speaking on the Zoom. Well, he's looking down, assuming it's his police report, because after he looks, he says something that appears that it probably is in the police report. And that's not allowed if you're on the stand. Also been in Zooms where Assistant DA was looking at the screen, but constantly looking above after each question or topic that came up, clearly indicating to me there was somebody on the other side of the camera giving him either some sort of signal or whiteboarding or whatever. So I think that isn't fair either and shouldn't be allowed. I don't know how we stop that, but so I think Zooms are okay for some issues, some court appearances like pre-trials and things like that. But as far as a trial or a hearing, would you force a trial on a Zoom?
No, I don't think I would. I agree with you. When we use Zoom, it is appropriate in some instances, not in all, and there is a loss of control because you don't know what's going on behind the scenes. So I think, we're doing the best that we can under these circumstances, but I agree, we shouldn't rush everything forward for the sake of time if we can't do it appropriately.
Right.
I think that's more important. So
The other pet issue I have is, did you ever see the pretrial conference forms? Of course you have. On the back of it, little area that asks you whether or not you're going to have a jury trial or a jury waive trial. It asks you to check a box. Some forms I've seen in parentheses, colloquy to be given when you sign that like box. So how does a defendant select a jury or jury waive trial without knowing the judge?
Well, I think that question is multifaceted in the sense that, in theory, everybody should be getting the same form of justice, every judge that they sit before, fair, impartial, and we shouldn't be able to dictate an outcome of a case just by who's sitting on the bench. It should be determined by the facts of that case. But I understand where you're getting at, the apprehension of a defendant making those choices, factors unknown. I think even in the context of where we are with the pandemic, now making that choice may be that you're going to have your trial in a month, or you may have your trial in a year or two. So I think for a defendant to make that choice with so many factors is difficult.
Well, I agree with you that, you know, you want justice to be equal, whatever that is. I don't know what justice is anymore. Here, depending on the outcome of a trial, one side said they get justice, the other side said they didn't. So I don't know what that term means anymore, but that aside, you know, if every judge was the same, I would agree 100% with you, but they're not. Fortunately, there are judges that I know, and you may know, that have never said the word not in front of guilty in their entire career. So that is not somebody that, if I was a lawyer, I would elect to go jury waived with. And the reason the reason lawyers and clients decide that issue is based on the judge. Because as you probably know, us lawyers sit around courthouses and we talk about judges. Clerks too.
Yeah.
Clerks more important than judges. But we talk about judges. To get a handle on them if we don't know their history. And if a local lawyer, if your witness said to me, I wouldn't go jury waive with that judge, that's a pretty good indication to me that I shouldn't do it either. People say, well, that's judge shopping. I disagree. It's not judge shopping at all. When I sign that document at a pretrial and get a date a month or two down the road, I don't know who's going to be sitting that day. When I show up for a trial in the district court, I don't know who's sitting in courtroom 1 or courtroom 2 that day. There may be a schedule that somebody showed me, but I don't know whether the judge that was supposed to be there had to take a sick day or couldn't, or get put into another court that day, or is in another session, not the trial session. So to me, judge shopping is if I get to a courthouse and I'm in courtroom 1 and I don't like that judge in the professional sense, but I like the judge in courtroom 2, if somehow I can arrange to have that file taken from one courtroom and put into another, I'd say that's judge shopping. But that's few and far between that somebody, number one, can get to do that without alerting some people as to what you're doing. So, you know, I take when that question on the back of that pretrial conference form asks whether or not you're going to pick a jury or non-jury, I write in, I cannot make the decision at this time. And only one judge has said something to me about it. And I said to him the same thing I'm going to say to you. And the same thing I'd say to you if you were on the bench and I was before you. 5 Supreme Judicial Court judges in this Commonwealth at a public hearing stated that it would be ineffective assistance of counsel and malpractice to waive that right without knowing the judge that you are going before. So I wouldn't want to be incompetent or commit malpractice. And I'm sure you as a judge wouldn't want me to do that either.
Absolutely not, Councillor.
But in some counties, they take that, and they want to have the client give up that right there without knowing. He comes back, the judge. If you're sitting on the bench, would you make a client give up that right before?
I would
knowing?
not.
Okay, thank you. I don't have anything else. I think you're well qualified. I think you're going to make a wonderful judge.
Thank you, Counselor. I appreciate that.
You're welcome. Thank you.
Thank you, Counselor. Counselor Devaney?
Thank you. Nice to see you again.
Nice to see you.
I appreciate all the time that you afforded me. I think it was 4 hours, but I got to know you as a person rather than just these papers. And that's very important to me, and that's why I meet with everyone. And I just want to say that, boy, you were right up to the mark. You have 18 months in this process to be appointed. And you filled your application out November 2019. 16 months now. Congratulations.
Thank you so
did
much.
it. Now, I always like to ask the nominee to, to tell us the journey coming here. I know it's 16 months. I know that. I know you applied 8 years ago for 2 district courts and were rejected. And that would be Governor Patrick? Could be?
Correct.
So you were approved by the then JNC both times.
Yes.
And rejected by the governor. So thank you for reapplying. Because sometimes I know I talk to lawyers and they don't reapply because they saw someone that got the job really wasn't that qualified. So that's the thing. I really appreciate when people reapply. Okay, so let's go back to your most recent JNC interview. When was that?
July 21st of
July
2020.
21st. Okay, so for the public, there are 21 JNC Judicial Nominating Commission members. These are 21 lawyers that the governor has appointed with the most awesome responsibility to decide who they are going to interview for a clerk magistrate or for a judge position. And as I've said, they have more authority than any of us. We're not even told how many apply. I don't expect to know who applies, but I'd like to know how many, but that's a secret. So what I'm saying is that there should be 21 people that interview you and every nominee for clerk magistrate and for a judge. And there was, I've been here a long time, 21 years, and I remember years ago, there was a JNC chair, and he told those 21 lawyers who had this responsibility, if you don't go to the hearing of that nominee, you don't vote on the nominee. But guess what? With this JNC and this administration, there never has been 21 at any hearing. And yet they all vote, never see the person, never heard, never talked. So it has nothing to do with you. You did it and you were well qualified to get through it. But I want the public to know, they think that we have so much authority. Believe me, we don't. The authority we have is to give our advice and consent to vote yes or no, and that's it. So you can see why it was so important for me to meet with you. And it was really a delight. I thank
My
you.
pleasure. Thank you.
So now having said that, how many of the 21 were at the hearing?
Well, I don't know how much COVID impacted my hearing because I got the letter in March saying I was going to get an interview, but then as we know, COVID hit and things were shut down, so that interview didn't take place until the third week.
Yeah,
in
Zoom
July.
has taken over, I know, yeah.
Right. So when I was there, the chairman of the JNC was there And everyone else appeared via Zoom.
Everyone, how many?
I believe there were 11 or 12.
Yeah, 11 or 12. Here's my point. 9 people will vote for you. I wouldn't do that in my position here. To vote for someone I never talked to, never seen, the whole thing. But anyway, you know what? I live by the serenity prayer. I try to accept the things I can't change. But anyway, so congratulations. And I'm delighted. 31 years. 31 years. We don't always see that. And for me, that's very important. And it's not only for my position to vote for someone to be a judge, but it tells it, I asked myself the question, does this person have life experience? Someone 40 doesn't have the life experience to be on the court. I know there has been exceptions in the past, but I think really you bring that all. And you've done a lot in your life. You've been very involved in your community and Boy Scouts, Girl Scouts and everything. And I'm impressed with that. So, okay, so let's get to your experience. You worked in a firm. Tell me, how did you make that decision? How did that come up that you would go into a clerk magistrate assistant position?
Well, back in the day, the trial court used to have what they were called 90-day appointments. So while I was waiting for my bar results, I did a 90-day like internship or position at the Middlesex Superior. Got a taste for the court and I loved it. But soon after that, I applied for and I took a position at the firm. But in the back of my head, I always thought about that experience that I had with the court and I enjoyed it. And in 1993, or probably advertised in 1992, the Middlesex Superior Court was filling the position of the first assistant clerk. And so I applied for that and I was very fortunate to receive that appointment. I worked with Eddie Sullivan, who was then the clerk of courts, had been the clerk of courts for 42 years.
He was the best.
The best. And I would say that's where I really learned the meaning of being a true public servant. If anybody knew Eddie Sullivan, they would know he was a true public servant, and he would remind us regularly that the public, they're the ones who pay our salaries, and we are there to serve them. And I think one of the things I've carried with me from working with Mr. Sullivan is that when I got to Gardner and they were installing a phone system, you know, I hate automated calling. I hate when you have to push a lot of buttons. And when people are calling.
Excuse me, that's all we're having now. People are on the phone for hours trying to get through an agency, you know?
Exactly. And I think when the people are trying to get through to the court, they're usually distressed in some way. You're not calling just to chit chat with us. You know, you have a reason why you're calling. So although I wasn't unable to have my way, that there would be no automation, I did insist that my phone system be set up that after you have the initial recording, you push one button, any button, and you get a live person.
Wow.
Because I wanted people to be able to speak to someone and help direct them in the right way. I didn't want to have to listen to directions and every department name and all the rest of it. I wanted us to serve the public and be available to them person to person.
Great. Can you tell us anything else that you, what other innovation that you established since you've been in the court?
Well, in Gardner, you know, we were a freestanding court, and then in maybe it was 2007 that the Winchendon District Court closed and they were physically moved into our building. At that time, there was a clerk magistrate for the Winchendon Court, and he came with his staff. In 2011, he retired, and I was appointed the acting clerk. And what I found frustrating is that we were operating 2 courts out of one building and operating as 2 separate courts. So lawyers would come in, say, on a Tuesday to handle their Gardner case, and then they'd come in on a Wednesday to handle their one Winchendon case. And so it didn't make sense to me. It was a lot of wasted time. These lawyers are trying to make a living. They're spending a lot of time going back and forth to court when we could condense that. So I basically consolidated the 2 courts from the outside eye. Inside, we're still running 2 separate dockets, two separate cashiering systems, two separate budgets. But for the people that we serve, for the lawyers that we serve, for the litigants, as far as they know, we're one court. They can come in on any day and address all of the cases that they have on that day, for judicial economy, to save money, to save time. And, that was something that I would kind of harass the trial court over, saying, we've got 2 of this and 2 of that, and there's a more efficient way to. So I think, that is one way where I think I help innovate the court.
That's great. Now, I was amazed in the years that I've been here that you had so much responsibility. So we talked about it. I listened, you told me about it. Now, so would you tell the council about all the responsibilities that you had in your position? Yeah, in assistant and clerk, because I have been here and I've listened and I never heard so many, that you had so many responsibilities to
In terms
do.
of being a
Yeah.
clerk magistrate in
Yeah.
the district court?
Yeah.
Well, a clerk magistrate, basically wears 2 hats. You have the administrative hat where you are, responsible for your staff, the hiring and managing of the staff and, ultimately the records. And then also your, quasi judicial duties where you are approving criminal complaints every day. You're issuing search warrants. You are conducting show cause hearings, conducting small claim trials. In my instance, when I was first appointed to Gardner and the Winchendon District Court, the Winchendon District Court was located still in Winchendon. We had one first justice who traveled between the 2 courts. So unlike almost any other district court, there would be days where there would be no judge in the building, which is very unique to the Gardner Winchendon district courts. So on those days, I basically conducted the judicial duties. I would arraign defendants, I would hold bail hearings, I would
amazing.
hold detention, probation detention hearings. And so I got a lot of experience that I think many other clerk magistrates don't have the opportunity to get because of the setup. That changed once the Winchendon Court moved in. That was some period of years. So it gave me a unique opportunity to really hone my skills in those areas.
So tell us about some of the hearings. You had probation detention hearings, bail hearings, criminal pretrial conferences, and you've had show cause hearings talking about rape, murder, kidnapping, drug trafficking. Tell us how you conducted all of those functions.
Well, I think to me, one of the most important roles of a clerk magistrate is the show cause hearings. It's at that point where the clerk magistrate is really the gatekeeper in terms of what cases flow into the system and what cases are diverted. And I think that's where I draw my most satisfaction from conducting those hearings. So many times you have individuals who come before you in the show cause hearings who don't have criminal records, who have made a mistake. And I have the opportunity to look them in the eye, to hear the facts of the case, hear from the police departments, and make a decision whether or not to find probable cause and push that case forward, which then puts them in the system. And many times I don't think that that is a just result. And I've chosen a different path. I've held it. I've imposed conditions, hopefully for the benefit of that defendant to correct whatever may have, pushed them into getting involved with the court system. And in fact, giving them a second chance, a second bite at the apple so they can maintain their record, they can go forward with their life without having to disclose on a college application, on a job application that they have a criminal record. And I do think everybody deserves that chance. And that's where the district court is so important. It gives you the people the opportunity.
Well, I have to tell you, I don't know if they all would have the compassion you have to do that, because I know someone that's in that position that all his life that's followed him, a fight on a yard with someone. and that, I thank you for that. That's wonderful. You've helped a lot of people.
I think I take
Yeah.
the most pleasure in that.
Yeah. So, tell me, what was the most serious that you had with a murder or a rape?
Well, in Gardner, a couple of years ago, we had a very vicious murder, and it was drug related. And the state police were obviously involved, and the Gardner PD, and I was involved in issuing multiple search warrants for that case, and then ultimately issuing the criminal complaint for that case. It was ultimately transferred out to the Superior Court, but many times all of these matters are initiated in the district court, and we're there, when the cases search warrant for those cases.
Well, I have to tell you, and I even wrote it down because I never got so many adjectives in my life from anyone favorable to you. And I got a call from Ian Colicchio, who is a clerk magistrate, and you have worked with her, you have covered for each other and all through the years, and you've known each other maybe 30 years, if I'm not mistaken. And she said that you are intelligent, you are gracious, you are considerate, you're kind. Well, we shut the door, get the noise level down. I'll go on kind, intelligent, well-rounded, professional, compassionate. And she said, and she is just the person I would like to see as a judge in my court. Can't get better than that.
Anne's a lovely
But,
person.
yeah.
And
So, yeah, so I want to ask you some questions, philosophy, okay? All right. Did you vote on the marijuana question? How'd you vote on that? That was a few years back.
I think I voted yes on the marijuana question.
How do you feel about it now?
I think I feel comfortable with that decision.
Well, we're having a lot of problems in little towns. I can't remember the town, little town, and they voted yes. And so it's a very rural area, and they had this huge blueberry area. I'll call it blueberry patch because I'm not familiar. And so the citizens there wanted to take back that vote because they were going to turn it into a marijuana area. And they can't. No town or city can change that because if your community voted yes, that's it. Zoning, planning board, no one can change it. So that's what we have. I'm in 4 square miles and we have 3 and 3. So I guess it's a yes or no, whatever position you have on that. So I guess that, I do have an opinion because I have 2 friends whose sons died of overdose of heroin and they started on marijuana. That doesn't mean everybody does. There's people that enjoy it every day and they'll never go any further. But I guess it's just your own experience, So what's your opinion about increasing the age of the juvenile court?
I mean, in terms of between juvenile and say district or superior court, raising the age, I'm in favor of that.
You are.
There's a lot of science that says people's brains are
Not till they're 25.
right.
And I had 4 children before I was 25, and my brain was very formed, okay? I really hate hearing that. You can't go by a book, okay? I went to college very late with 4 children, and I was in a child psychology class. I never brought this up before. And I was young. The teacher was probably the same age as I was, a young woman. She said that mothers talk more to infant girls than infant boys. And I raised my hand, the worst mistake I ever made. And I said, I have 2 boys and 2 girls. They had no sex. I talked their ears off when they were babies. She got me after class. She didn't want me in my class anymore. So she gave me another chance. I never commented again. And it was the hardest class I ever had because I had to try to throw out all my life experience and give her what she had in her book. So I disagree. We just had a 21-year-old that killed 10 people, 8 people. Should we blame it that his brain is not fully formed? I'm going to get off off this, okay? Because I'm very opinionated and I shouldn't be, and I appreciate your opinion. Okay, so tell me, what was the most serious case that you've had? Probably the murder case, probably a rape case. I think the thing that I am so upset about, and we see it day after day after day, that mothers and their boyfriends are torturing and killing their children. Does that come before you? Did you had any of those?
Well, we certainly have had our share of domestic violence cases. We certainly have had our share of cases where children, were victims of abuse. Absolutely.
Yeah, well, it seems like the criminals are getting younger. And we saw just a couple of years ago, a 15-year-old raped and murdered his teacher. I mean, this is why, really have to look at these laws. What do you think about, what's your opinion about minimum mandatory sentencing?
Personally, I'm not in favor of mandatory sentencing.
Well, I think the judges should have discretion. I think that's what that whole thing is about. So, okay, we talked for 4 hours and we even got into, and I don't know how far afield we got this. I had never talked about it before, but I mentioned to you that I'm concerned that we see a lot of animal abuse. And when you read about the torture that they've done to the animal, it's a one-day story. You never hear what the sentence was. And I don't think it's very much either. Now, I told you this story and I'm going to share it with my counselors. Judge Michael Pomerol, when he came before us years and years ago, counselors, well, only Paul's here, he was not here, we're the only, when he was a lawyer, when he was a practicing lawyer, he was the only person in my whole tenure that got an award from the Animal Rescue League. I don't know why, we talked about it. And I said, that meant a lot to me. And the Animal Rescue League, and they kept it a surprise, they had an auditorium built to give him an award for the cases that he has brought against animal abuse. Now I want you to tell me, and I was devastated, but I want you to say it again publicly about your experience with the torture of and murder of bears, B-E-A-R-S.
We did have a case that involved some hunters who were baiting bears, which if you're not familiar with that, they place food out for, and they had a tree stand and shot the bear and killed the bear, and baiting bears is illegal. And the environmental police came to me looking for a search warrant because they were trying to track down the bear carcass so they can bring and make their case against these hunters. And so I had never had experience with that, but these people, after shooting the bear, were bringing it to a taxidermist so they could have it stuffed. And so they had the entrails from where the bear was slaughtered in the woods, and they wanted to match that DNA with the excuse me, which
You should have some water.
They wanted to try and match with DNA the entrails that were left behind with the carcass of the bear that was sent out for taxidermy. So, I mean, it was a horrible, horrible crime, and the bear was just, obviously looking for food. But I don't know, I think I may have been the first and only person in Massachusetts to issue a search warrant for a bear carcass. And they were in fact able to obtain the bear carcass, match the DNA, and charge the individuals.
Imagine, no, that's a first, but, no, I think, animals should be protected. So, now, really, your training for all the things that you have been responsible for, and you didn't really go into all of them that we did when we met, but I was surprised that you had to oversee all of those things. Do you want to go into that, or what? You have, and you've been a chair of so many things and members, and so I think that, your experience in actually substituting for judges you have in times, that I think that brings a lot. So I am, I could go on and ask you questions. I think, well, let me just ask you this. What was the most rewarding result that you've had in anything that's come before you?
I would have to say one of the most rewarding cases that I was involved in was a show cause hearing, where a young lady came in and she was charged with drug possession. And as I was conducting the show cause hearing, she was there with her grandmother, and I was going through the facts, and I was reading it. I saw that there were other individuals with her in the car, and they were people who I have known as drug dealers and drug users. And I saw this young girl had no criminal history. She looked a mess. She was scared. And, being a mother and being someone who has had so many hours and years of experience, my gut instinct was that she was caught up in a circumstance, that this really wasn't who she was. And so I worked closely with my chief of probation, and I asked her, some questions and whether she would be willing, to take some steps to turn things around, and I would hold the criminal case in abeyance. And she agreed to that. And so we did some drug testing. Thank you, Sue. And got her some other support. And I continued the case for a while, and she came back to me with her grandmother, and they were so happy and so grateful. She had turned her life around. She didn't get sucked into the addiction cycle that could happen. And it's cases like that and things like that that give me the most satisfaction of being able to look at people and, see the good and give them a second chance and facilitate that happening. So times when I went home feeling really good.
I had brought it up to this administration. I'm very concerned about, with the pandemic, that we don't know the child abuse and the domestic violence that's happening. And it's happening, it's increasing. I've asked them if they would give a number. I haven't heard it lately. I hope they will give a number for people to call. We can't help the babies, but when children went to school every day, that child who was being abused maybe would talk to the teacher. Maybe there would be some signs the teacher would see, even physical. How can we have, which I have a lot of objections about their work, the Children's Agency, how can we have them get more involved to see in our society these people following up? They have closed the books on people like, that have been torturing the child, and we end up finding it in a bag in the river. 7-year-old boy who has been stabbed and is the weight of a year-old, and they close the books and that's the end of it. What can we do about that they follow up? These children aren't being protected in this pandemic times, and I'm really, really concerned about that.
Well, I think that's a huge concern, and I share that concern with you. I know in the district court, it's our practice, if while we're hearing a case and we have a restraining order or somewhere where we become aware that there may be a child at risk or a child who's being abused, to file a 51A and to get the agency involved and try and get that child some help and get that family some aid. But it is, as you're right, it's a huge problem, an overwhelming problem. I think in terms of my role as in the district court, I would try to be very aware of that and get the agencies that can help that family involved.
Good. Okay, now you worked in Superior Court and District Court. I know from people who are in the District Court what they say, and I almost anticipate that you're going to say the same thing. Tell me the difference of being the Superior and the District Court and your personal feeling about it.
Well, I think when I went to the district court, I knew I had found my home. I love the Superior Court. It was a wonderful place to work, but it's a much more sterile environment. Most people are represented by attorneys. The issues that they're dealing with are somewhat removed. Not always, obviously, especially on the criminal side, but for the most part, whereas the district court, I think Chief Justice Connolly used to always say this, and I agree, the district court is where the rubber meets the road, right? I mean, this is the nitty gritty. And, when I was in Cambridge, I would go upstairs to the Cambridge District Court, which is a couple floors above me, and I would just see those hallways packed and bustling with people. Whereas in the Superior Court, kind of empty hallways, we had 24 courtrooms running, a lot of space. In the District Court, people were shoulder to shoulder, and they'd come there asking the court to help them with a myriad of issues, and that I think was the impetus for me to apply for a clerk magistrate's position, because I wanted to, get into the nitty gritty and be involved with the community and being, able to help individuals resolve whatever issues they had. And they come to the district court with all kinds of issues. People think the court has an answer to everything. We don't always, but I try to make sure that anybody who walks into my court goes out with some piece of information. If we couldn't resolve the issue, I try to point them to the court or the agency that can, or the phone number for, the Bar Advocates Program. Give them something that can help them, because that's what they came to the court for, looking for help. And I think that's our duty.
Right. Well, in my experience here, talking to judges, they all say the same thing. The district court is the people's court. And they would never want to be elevated to any other court. They love what they do. And I have seen clerk magistrates who have given, and I'm sure you know, money to people to take a bus home or give them a lunch. That's what I have experienced here. And I just want to say, I think the saddest thing I have in my position being here this time, that there's so many wonderful people, judges, who have reached 70 and retired. And one of them is one of the judges you're replacing, Judge Calagione. What a wonderful person. He is the people's court. So, I'm sure he must be very pleased to see you moving up to that position. So, I enjoyed all the time that we spent, and personally, I always wanted twins. I never had them, so I'm jealous. So anyway, I wish you all good luck. I mean, everyone has said so many good things about you. And as I said, I wrote down Ann Colicchio's, all her comments, but that's means a lot, because that's not public, that's your personal. And I can't separate your personal from the public, and it's excellent. And I'm so pleased that you have got through this time and that you will be serving in the district court. Thank you so much.
Thank you, Councilor Devaney. Appreciate it.
Thank you, Councilor Devaney. Councilor Kennedy?
When you were in Middlesex Superior Court, did you primarily sit in civil sessions?
I did a little bit of both, and a good majority of my time was trying to juggle the 24 sessions and keep them up and running at the same time.
I remember I was floating around the first session back in those days when we were sending them out everywhere in the world. The judges there, I think, that time were Judge Gorbeau, Judge Zobel, and
Yes.
various judges, I'm trying to think who else was there. But yeah, did you do, I'm just curious about your civil background. You had a little bit when you were in Malden, my next door neighbor from Everett, and a little bit in Newburyport, it looks like. But how much did you actually do sitting in this, in Superior Court?
I would spend, I would say probably equal time in both the criminal and the civil.
And in Gardner, I assume like every other court, there are more civil filings than there are criminal filings. Is that fair to say?
Yes,
Okay. And do you actually do civil trials there? You ever get to any of them?
we do, actually.
Okay. 'Cause
And we actually had one on Zoom, which was very, very difficult, but we have one, had one during the pandemic.
what kind of case was that?
I think it was an insurance case.
Okay. Yeah. You know, 'cause civil trials, my experiences with judges, especially district court judges, is they try to run away from them. Do you think that's true?
Well, not in Gardner.
Well,
We
maybe
don't
not.
run away from anything in
But in
Gardner.
general, do you think they run away from civil cases? Most of them want to do criminally. They don't like to get tied up to civil cases because it involves a lot more writing and a lot of rulings and findings and things of that nature.
Well, I wouldn't disagree with that assessment of it, but I think in Gardner, I've been fortunate enough to have judges who I think have, taken on the civil as well as the criminal. But yes, the criminal is a little bit more flashy, a little more glamorous.
Okay. Well, we know we have more civil filings than we do criminal filings in Gardner, because you already said that. How many criminal trials would you say you do in a year, and how many civil trials would you say you do in a year?
Well, I couldn't give you the exact number, but I would
Yes.
say we do far more criminal trials than civil trials.
Even though there were a lot more civil filings.
Yes. But I also think, similarly to criminal, I mean, a lot of things resolve before the
Sure.
trial date. So
Yeah,
I
no, I
think,
understand, but insurance companies tend not to give up their money in civil cases until they're on the courthouse steps, and even then, it's a struggle.
that's true. That's true.
Do you think, there's been a lot of talk about implicit bias in the court system, both in terms of all kinds of issues people that come before the court. Do you think that exists?
I do.
And do you think an African-American male going into a district court is more likely to get a harsher sentence because of that implicit bias than, say, someone who looks like me?
Yeah, I would hate to, I hate to think that, but I think that history has shown us that that's probably
That's true.
true.
It is true.
Yes.
We now recognize it's true. The question is what we're doing to try to fix it. I have to be honest, I don't think we're doing enough yet.
I agree.
We're on the way, but we're not near enough. And that applies to all kinds of implicit prejudices that are built into the system. I don't know of a single judge that I've seen has an explicit bias. If they did, they shouldn't be sitting. But it's human nature. What about insurance companies? You talked about that insurance case that was there. Do you think insurance companies tend to pay less to people of color in terms of personal injury type cases and other cases than they do Caucasians? Do you think the settlements are less, the judgments are less?
Honestly, I don't know. I mean,
You think there's an implicit bias in that side of the system?
well, I think we're learning that there's implicit bias everywhere. And that's part of the problem is trying to recognize and educate ourselves. So if I were to apply that, that I would say, yeah, that's probably true. I don't know it for a fact, but I think there's definitely a possibility.
How are you going to be able to handle civil cases? Do you think you're up to speed on those? I mean, the criminal side, in one sense, is easier. There's no question about it. It's easier to learn. It's easy to do. You've sat in a lot of criminal sessions. The types of cases you're going to do, driving unders, domestics, assault and batteries, drug cases, you've seen 1,000 times sitting in Gardner Court. You've seen judges handle them. What if somebody comes in with a complicated contract case?
Well, I think I'd be able to handle it. And I think, also I have the ability to know what's coming up before me and educate myself in any way, before the trial. I mean, it's not like it would be a surprise, or it shouldn't be a surprise. If I'm doing my job, I'm going to know what's coming up on that court docket, and I'm going to educate myself in any way that I feel that I may be lacking. But, I think I've had experience on both sides.
Right.
So
you know, that cuts both ways. I admire judges when I go in, especially in Superior Court where there's a motion for summary judgment on or some type of complicated motion before the judge or even a pretrial, and they come out for a pretrial hearing on it and they've read all the materials. It can be pretty hefty, as you know. But I don't want them doing that in a criminal case because I don't want them prejudging it. I don't want a judge reading a police. I've gone in the courts many times in district courts, and the judge has already read the police report before we start a trial, and it prejudices them before they start. Have you seen that? Judges do
No,
that?
I don't recall really my judges going through the criminal stuff before.
I've seen it a lot where they've read it ahead of time. They've even commented on it ahead of time. I read the police report. Well, if the police report was all there was to it, we wouldn't have a thing called a trial, right?
That's true.
You know?
That's true.
We've known each other for a long time. We've had discussions about your judgeship going back to your first application when I was first introduced to you in Gardner Court. I do remember you from the Superior Court. I think you were on one Superior Court trial I might have had with Judge Zobel one time, a criminal case way back in the 80s or something. But I think you're going to be a terrific judge. I mean, I'm really pleased by your nomination. Casting a yes vote next week.
Thank you, Councilor Kane. I really appreciate that very much.
And I have to mention the calls I got, especially Leo Farmer, who was all over me, who was my good friend and a New York Law School classmate.
Great guy.
Thank you, Councilor Kennedy. Now we'll go through the councilors who are remote. I'll go district order. So Councilor Ferreira, would you like to ask any questions?
Thank you, Mr. Chairman. I appreciate it. The nominee and I had substantial conversations over the last week or so, and I was really delighted with the qualifications and her demeanor. I've spoken to a lot of people, you know, there's just one question that comes to mind, and I hope you don't mind me asking this, but I know you're a collegiate basketball player and got a free ride, and I also heard that you often went to Buffalo Wild Wings after court sometimes, and you took advantage of defense lawyers in basketball shootouts. Now, Councilor Kennedy claims to have had a college basketball career too, and I just want to know if you took advantage of him at Buffalo Wild Wings.
I did not, and I would not until he casts his vote next week. But after that, I think he's fair game.
Okay, I have no further questions. Thank you.
Thank you.
Thank you, Councilor. Councilor Iannella?
Thank you. Can you hear me there?
I can.
I just have one question as well. When you spoke with Councilor Juvenile, you know, on the issue of jury trials, and you talked about as long as the environment was safe, you would have no problem with resuming jury trials. Let's assume a jury trial is scheduled, let's say, I don't know, June 20th. Assume that's during the week. And one of the participants, whether it's the defense attorney, whether it's the plaintiff's attorney, let's say it's a civil case, or the witnesses, I don't feel comfortable. What are you going to do at that point? Are you going to grant a continuance? That's my point. Sorry.
Well, I guess I would have to explore it beyond that. I don't feel comfortable, you know, and drill down.
Let's explore it. What do you mean by that? We can explore it now. Make believe I'm one of the people who say I don't feel comfortable.
Well, I guess I would inquire why they didn't feel comfortable.
Well, I haven't had, I unfortunately haven't had the vaccine yet. We'll make it real easy.
And what party is this person? Is a juror, you said?
No, it's either defense attorney, if it's a criminal case, it's the prosecutor, or if it's a personal injury case, it's the personal injury attorney. We'll go that way first. Oh, we can keep going down the line. Well, let's do that part. Those are the attorneys in the case.
Well, I think, again, I would have to evaluate the environment that we're in. If there were precautions that, you know, the CDC and the state feels make the environment safe. And have a further, discussion with the other parties and see what their feelings were in terms of continuing the matter and what impact that may have on the parties. I think one
Well,
thing COVID
That's actually troubling to me. I've been vaccinated, but let's assume I haven't been. I don't feel comfortable. I'm really nervous about it. I don't want to participate. I mean, you may say 6 feet, but there've been people who are 7, 8 feet apart that have gotten COVID. So I just do not feel comfortable. It's going to stress me out. I don't think I can do an effective job. That's not good enough for you.
Well, I think with what you've just added, when I said I would explore with them why, all of those factors need to be taken into consideration. And kind of hearkening back with the conversation I had with Councillor Juvenile is that, we have to make sure that we're delivering justice. We're not just getting the job done. And I think one thing COVID has taught us is that we need to be able to be flexible. And we're actually taking a much broader look, at all the facets now of jury trial and the court system, which I think we wouldn't have but for the pandemic. So yes, if someone's before me saying they don't feel comfortable, they can't perform their job, and that's going to have, an impact on all the other parties, yeah, then I think that I may need to continue that case.
But it wouldn't be an automatic continuance.
Well, I think just on the blanket statement, I don't feel comfortable, probably not. Like I said, I think I would have to hear more and understand why.
Yeah,
So
that's
I don't
actually
think I would-
troubling. That's actually troubling to me. And I'm here right now. I'm not going anywhere. Like, what more would you want to find out? In other words,
Well,
I just said, I don't feel comfortable. I'm nervous of getting COVID. That's the
Right.
situation.
Yes, that's when you initially said, I don't feel comfortable. I said, I would want to then ask why. And then you expanded and said, I don't think I can do my job. I'm afraid of getting COVID. And that would be the type of information that I was looking for. What was the reason for the discomfort?
And would that be a reason to automatically continue the case?
Well, I guess I wouldn't say automatically. Yes, that would be a reason that I would consider continuing the case.
Okay. I don't want to give you a hard time, but
That's
a
okay.
lot of lawyers have asked me this question, and I'm not getting you're basically saying, yeah, I'd consider it. Well, I'll consider it, but you could easily come back after considering and say, yeah, we got to move cases or we have to do whatever. And your motion to continue the case because you're afraid of getting COVID is not good enough. We've asked other people and we get different answers from different prospective nominees. Everyone's different. I know who people who want to go to a restaurant. Some people, even if there's 10 feet of social distancing, they don't want to go. And we know the CDC guidelines. They don't want to go. But if someone says, you know what, I don't want to go. I just feel awful. I haven't gone to a restaurant. I haven't gone anywhere. I don't even go grocery shopping. And now I got to do a jury trial because Judge so-and-so says, the CDC guidelines. I haven't gone on a plane. I haven't done anything. But I'm getting the impression from me, you'll consider it. But under what I just said, that's not an automatic reason to have the case continued.
Right. Well, I can tell you, Councillor, from my actual experience during this pandemic, I have several attorneys who have not come into the courtroom at all because they don't feel comfortable. And I have made every consideration and I've handled their cases and kept their cases on track, whether it be via Zoom or a telephone conference or a Polycom conference, so that I could work with them and they could feel comfortable, in the environment there. So in a practical sense, I have done just that. There's probably 2 or 3 attorneys who are regularly in my court who don't feel safe coming in, even though we have the plexiglass and even though we have a limited number of staff. So I guess what I was listening to when you were asking me is being very conscious of when you use the word automatic. I think I don't want to be one of those people who automatically does anything. I want to understand what people's concerns are, and I will respect that, and I want to make an informed decision about that. So I think maybe I was being tripped up a little bit by the word automatic. And then soon as you expanded and said, well, here's why I don't want to go forward. I don't feel comfortable. I don't want to get COVID. You know, that has an impact on justice. And I think that that would be a reason for a continuance. But in the practical sense, I have been very flexible and believe people deserve flexibility in terms of their concerns around this pandemic.
Thank you. I should have used the term more likely than not.
Well, I think that was me just trying to really listen and dissect the words, but
Yeah, no, it's my fault. I assume if I use that word, that maybe you'd be more amenable to a continuance if I use the words more likely than not.
yes, Council, I would.
Yeah, other than that, that was a concern I have because lawyers, you know, even what you just said, you know, you've been flexible, or you would be flexible, but they really haven't had jury trials. Well, they just maybe just started, but you know, motions, that's a different scenario. Jury trials is a total new game. I mean, that's, and I understand. I mean, there's so many criminal cases that are way behind. The backlog is really substantial. But again, I think you have to consider all the factors. And I know you said you would, but there's a lot of attorneys out there that don't feel, whatever the word is, doing a jury trial. And I don't know about you, but I know people who won't go to a restaurant, indoor restaurant. Are you kidding me? They just won't do it. And you know the CDC guidelines. You know, they got the plexiglass, they have the social distancing, the certain amount of capacity, just like you'd have a jury trial. They just don't want to do it. They don't want to do it. So I just hope that you'll think of that when somebody comes before you about a continuance. And everybody's different. Everybody's different. Maybe the first 5 people are totally feel at ease doing a jury trial, but maybe that other person, for whatever reason, maybe that other person has a story where a family member died of COVID. I don't know, but I hope you'll really be cognizant of that fact that if someone comes before them, you'll be sensitive to that, and hopefully you'll grant them a continuance if that ever happens.
Thank you, Counselor.
I don't have any other questions. I think you're going to be a great addition to the court. And when it comes, your nomination comes before us next week, I want you to know that I'd be more than happy to support you.
Thank you.
Thank you.
Thank you, Councillor Iannella. Councillor Hurley.
Yes, thank you. Good morning.
Morning, Counselor.
We talked last week, and I just got a few questions, but one of your biggest fans is Councillor Kennedy, who from day one said that you were great. So you've been a clerk for a long time. What is your philosophy on bail?
Well, I mean, I think the presumption is that everyone should be released on their personal recognizance. That's where we start. And I think the recent SJC cases, you know, talking about how we need to take everyone's personal financial situation into account is also very important because, you know, $100 for one person might as well be $1 million. And so I think that it's a very important part of the process and shouldn't be taken for granted. And I can tell you that so many people who have never needed to make that decision to set bail or to hold someone maybe don't realize what a huge undertaking that is, to take away somebody's liberty, to take away somebody's ability to go home to their family at the end of the day. So I think that's something where I think the court needs to spend time and understand what the risks are to that individual or to the public and make a very deliberate decision when they're setting bail.
What if they had a 3-page record for drugs and guns?
Well, again, I mean, you obviously have to take that into consideration. And when you you need to look at the cases, you need to look at the age of the cases, you need to look at the disposition of the cases, you need to look at all of those, those factors and whether they're going to be a risk to the community, whether there are less restrictive means to keep the community safe other than taking away their liberty. So, I couldn't make a blanket statement, not knowing what the specifics of that were, but I don't think necessarily when you say 3-page record, that means, oh, you need bail, or a 10-page record. It depends on what that consists of. Are they all motor vehicle offenses, or are there offenses of violence?
I indicated it was drugs and guns.
And guns, right. So again, on those cases which are more serious, especially the gun offenses, I would have to look carefully at whether or not this is a person who poses a flight risk or a risk of harm, and whether bail should be imposed. But not knowing the specifics of those, I don't know, but I think those charges would indicate a closer look.
One of the things you haven't done yet is sentencing. How would you go about determining what an appropriate sentence is? Not for a first offender, not for a second offender, not for a third offender, but for someone who has a really serious drug problem that's evident from a 4-page record or a 5-page record that consists of drug possession as well as larcenies under. Usually it involves cases where they tried to steal from, the big box stores or whatever to get money for drugs. And the argument is that this person shouldn't go to jail because they're a mother.
So I'm sorry, the last part is you saying the argument is this person should not go to jail because they're a mother?
Correct.
Well, again, I think this is where I say that I'm not in favor of mandatory sentences. I think when you're sentencing someone, the more discretion and the more flexibility a judge has, I think the better outcome. I mean, we want to deter, we want to rehabilitate, and we want to give support. And sometimes we need to punish. I mean, that's part of the judicial system, and that sometimes is the answer. But I don't think it should be our first answer or our go-to answer. When you see someone who has a record that's got the drug offenses, many times you will see those additional larcenies and things of that nature, because that's all part and parcel of addiction many times. I don't think taking people who have an addiction issue and locking them up is the most effective way. It doesn't address the underlying problem. It doesn't help them, necessarily rehabilitate themselves. So I think having the discretion at sentencing, and this is one of the reasons why I have applied for this position, because as a clerk magistrate, I'm doing the show cause hearings, I'm issuing the criminal complaints, I'm signing off on the complaints when they come in from the police departments, but I don't get to do that end part. And I think sometimes that's where you have the biggest impact on someone's life. And I want the ability to see the case through to the end, to try to work with the probation department and impose some conditions and some support systems where someone can turn their life around, where I can feel that satisfaction of saying, okay, I've safeguarded the community, but I've also helped this individual start a new life. And that's where I think the important work of judges come in. Ultimately, sometimes there is no other answer. Sometimes you've gone down all of those roads and you'll see on their record they've served 30-day sentences, 60-day sentences, and nothing's worked. And ultimately incarceration is the answer. But I think that would be the last quiver that I drew. I mean, I think we have a lot of tools, not as many as we should have, but there are tools available to judges in the district court that I think should be used to resolve the systemic problem that you may identify as the driving force, with that person's involvement with the court.
All right, thank you.
Thank you.
I have no more questions.
Thank you, Councillor Hurley. I just have one question I'm going to drive a point on, but first I just want to say that I think it's very impressive that you've been wearing the hats of Winchton and Gardner clerk, and that you've found opportunity to look for efficiencies and to improve the way things function. And I know that, Toy Town and Chair City, like every other part of the state, have their own unique set of circumstances. I've lived in Templeton, and obviously I'm honored to represent those two communities. And everyone I've spoken to who's crossed paths with you has had positive things to say, and that certainly goes a long way. I appreciate that there's been discussion today of access to justice, whether it's, hopefully what it will be the waning days of COVID, whether it's taking into account mental illness that defendants in particular may have, and making sure that they understand what's happening and are at ease in the courtroom. So the thing I want to touch on is how you'll exercise your discretion relative to some of the things that have been talked about. You and I had a conversation about show cause hearings. I won't ask about that again because it's been addressed, but the implicit bias and the things that were revealed in the so-called Harvard study on racial disparities, among other things, your discretion is where those systemic things hit the road, right? And so I want to take it actually in the direction of something that Councillor Devaney and I have a respectful disagreement on, which is juvenile jurisdiction and brain development in the early years. So, first of all, we have people entering the district court who've, already been through our juvenile system. It's kids who are in our foster system. It's kids who are disadvantaged. And in a lot of cases, it's Black and brown boys in particular. And, what I read from the science is that it's the male brains that tend to be developing slower or need more time into the 20s. That doesn't excuse behavior. To me, though, it's a factor among the penumbra that you would hopefully consider when you're making decisions. Is that something that would factor into your decisions, and how does it kind of inform your view on your role as a district court judge?
Well, that would absolutely factor into my decision, not only as a clerk magistrate, but as a mother, as a sister, as an aunt, as a human being. I think, I've had so much interaction with people, and as a person growing up myself, I know that I may not make the same decision when I was 17 as when I was 19 or 21 or 25. And so many of my show cause hearings involve young people who have made impulsive, poor decisions. And I don't think that is a basis where we should ruin people's lives for the rest of their lives. Again, you would have to carve out from that violence. I know that Councillor Devaney is concerned about that. And I don't lump someone, a 15-year-old who, massacres or is in a school shooting as the same as a 15 or 17-year-old who steals something from a drugstore, or so I think it has to be based on the facts. But I think we have an opportunity in the district court with young people for rehabilitation. I mean, they have a long and hopefully productive life in front of them, and we don't want to take that away for an impulsive, poor decision at such a young age. So, and I agree that your cognitive ability increases as you age and you make better decisions, and that has to be factored in when you're judged.
Thank you. And I appreciate that, not just as compassion, but pragmatism too, in terms of the goals of getting people back into society. I really appreciate your thoughtfulness today. I think you did a great job. I think your background speaks well to your nomination to this role. I'll happily support you next week after putting your name forward at the Council Assembly.
Thank you so much, Councillor DePalo.
And with that, we close this hearing.
Thank you. Thank you for your time.